except you can't see them because they're behind the firewall because somebody decided that those knowledge capture things might be subject to ITAR. And it's not just what the regulations actually say, but how they get interpreted, and in sometimes very conservative ways that is causing us a lot of problems. So the title of this panel discussion is Export Control Reform. What does it mean for commercial space? And our sponsors it's sponsored by Sierra Nevada. Our moderator and our chair is Franceska Schroeder. Franceska is the principal in Washington, D.C. office of Fish and Richardson. Her practice emphasizes export controls and economic sanctions, commercial and government contracts, risk management, insurance, legislative and policy matters that affect aviation, space, defense, and the national security sectors. Ms. Schroeder's clients include aerospace and defense contractors, satellite manufacturers and operators, launch services providers, system engineering firms, software companies, and investors in high technology products. The whole industry is affected by these topics. She's also a legal counsel to the American Astronautical Society and serves as a private sector advisor to the U.S. delegation to the Legal Subcommittee of the United Nations Committee on the Peaceful Uses of Outer Space. And in 2012, Mrs. Schroeder was appointed to the NASA Advisory Council's Commercial Space Committee. Please welcome our entire panel. Franceska.
Thank you, Wayne. And Pat, I'd just like to take a minute to congratulate you and your team on a wonderful conference. You put together this unique event in one of the most beautiful places on earth, and thank you so much for letting us be a part of it. We're going to run this panel a little bit differently than the other panels because basically we don't have a video and we don't have anything terribly cool to show you. So we're going to do entirely Q&A. I'm going to be presenting questions to each of our panelists, to which they will respond. We'll get some interactive dialogue between the panelists, and we're going to allow plenty of time for Q&A from the audience. And of course, you can also buttonhole us over lunch. So I'm going to start out, and I'm going to introduce each of the panelists. Their long bios are in your conference materials, so I'm going to keep the introductions relatively brief, and then we'll get into the Q&A. So I'd first like to invite you to welcome Mr. Tony Dearth. Mr. Dearth holds the position of Chief of the Aircraft Division with the U.S. Department of State, Directorate of Defense Trade Controls Licensing. So if you need a license, you got to go talk to Tony, and you'll see in a minute Bob as well. Tony is currently on detail managing the DDTC. DDTC stands for Directorate of Defense Trade Controls. He's managing the DDTC implementation of the Department of Defense U.S. exports system within the Department of State as the single IT system for adjudication of export license requests, fulfilling one of the 4 pillars of the Export Control Reform Initiative that we're going to be discussing today. He's been with DDTC for 9 years after serving 21 years in the U.S. Air Force. Next, I'd like to introduce Ann McFadden. Ann currently serves in the Policy Directorate of the Defense Technology Security Administration in Washington. Her most recent projects include the final section of the 1248 report that we'll be discussing today. That was the report to Congress on the risks associated with transferring space-related items off the United States munitions list. The United States munitions list, as I'm sure you all know, forms part of the ITAR. Ms. McFadden's space work started at Vandenberg Air Force Base in California, and she has also served as a government technology monitor at almost every commercial launch site in the world. It's pretty amazing. Next, I'd like to introduce Paula Geisz. Paula is manager of the International Technology Transfer Office within NASA at NASA headquarters. Excuse me. She was part of the 3-person team that created the NASA Export Control Program in 1995. She supported development of NASA export policies and procedures, NASA export license applications, management of NASA's Special Comprehensive License for the International Space Station Program, annual training conferences, and NASA representation on the Missile Technology Export Committee and other interagency forums. And lastly, I'd like to introduce Mr. Bob Warren. Bob joined the Directorate of Defense Trade Controls of the Department of State in June of 2004. as a defense trade controls analyst and has been responsible for export licensing for all categories of the United States munitions list. He is currently involved in export control reform as directed by the President and is engaged in rewriting numerous categories of the United States munitions list. He currently is the division chief for missiles and space at the Directorate of Defense Trade Controls, so he's someone that you would interact with when you need a license for your space projects. So with that introduction, I'm gonna take a seat and turn to questions, and then we'll turn to you. Thank you. So Tony, I'm going to start with you. So we've heard a lot about the Export Control Reform Initiative, and a question that I always get that I love passing to you is, well, what the heck is it?
The whole concept of export control reform is not new to this administration. The past 4 administrations have given significant lip service to the need to reform the export controls because the government has heard much from industry that we control too much and the controls are too onerous. This administration took a serious attempt at implementing some type of export control reform, and in 2009 announced a concerted effort to implement export control reforms. This was tasked down through the National Security Council and the National Economic Council, and they were both tasked with coming up with an export control reform strategy. In 2010, the President actually officially announced export control reform as one of his initiatives, and he indicated that there were 4 key tenets of export control reform. Currently, items that require export control are done by multiple agencies, done by the State Department, done by Department of Commerce, and also done by the Department of Treasury. So the first tenet, and what we like to call these are the 4 pillars, the 4 singles. We've heard them called many things, but they're the 4 key goals of export control reform. The first is to place all of that jurisdiction from a governmental perspective under one single agency. The second, because each agency has its own control list and its own control procedures, the second tenet was to come up with a single controlled list that would base the controls based on the sensitivity of the item. So it would be tiered in some way, shape, or form so that folks would not only know exactly what the controls are, but what they needed to do in order to export the item. The third was a single IT system. As you can imagine, the government, sometimes it's hard for us to talk to one another because we're talking in different IT systems. And so the U.S. Exports Control System, which was started by DOD, and DOD had vetted it out and proven its usability, was chosen as a single IT system, and that's a project I'm working on now. And the fourth was to stand up a single export enforcement coordination agency. So that, in a nutshell, is what export control reform is. Now, there's a lot of information out there on the website. You can go to export.gov, and it'll tell you everything that's going on with the export control reform effort and what the goals and objectives are. There's been a lot of sound bites out there, one of which that my boss doesn't necessarily like, but it does capture the essence of the export control reform effort. And that is, and this came from Mr. Gates when he was the Secretary of Defense, we want to place higher walls around fewer items so that we control those things that are the most sensitive to the U.S., both from a technology perspective and from a national security perspective, because it is our sons and daughters and aunts and uncles and fathers and mothers that are out there in harm's way doing the defense of the nation abroad. So that's export control reform.
So, and what's the status? It's been, as you said, it's been an issue that's been around for years and years. There seemed to have been a great push forward this year, and I don't know if it's because of the election or what, but there seems to be a slowing down of the momentum. What do you think the status is?
As we started to peel the onion on export control reform, as you can imagine, we found it to be a monumental task. The way the Arms Export Control Act was written and the way the ITAR implemented the Arms Export Control Act, the easy way at the time that it was written was to control everything. So if you have a highly sensitive item, let's just take something that everybody's familiar with, a fighter aircraft. We know that we don't want to sell that to just anybody abroad, and so rather than define each of the individual subsystems that we wanted to control, they wanted to control everything. That means, yes, even your nuts and bolts and washers and cotter pins, et cetera, lock rings, all ended up falling into a catch-all control. So one of the tenets and the hardest part of export control reform was to do an analysis of each of our systems and determine which are the critical subsystems. That's been an engineering marvel in and of itself over the past 18 months to go down through the list of all 21 USML categories to try to define what has been done or what we should control. For public comment, we have released for public comment draft rules for over half of those commodities. The other half, except for 2, are in the draft stage and sitting at OMB for sending out to the public for comment. Due to election cycles, there are certain things in the government which don't happen as a lead up to an election cycle, such as the publishing of draft rules. The government, even Congress, tends to go on a bit of a slowdown going into an election cycle. So there has not been an intentional slowdown or a wait-and-see posture taken by the government. It's just been the natural course of the way the government itself operates when we're in these election cycles. So we have published over half of them for public comment, the draft rules. We've published some other draft rules, such as the implementation and transition plan regulation and some definitions like specially designed and public domain. So that we are making progress, and we're still working on getting things done.
Great, thank you, Tony. So, Luann, Tony has explained how much work has been done, and it is an unbelievably significant undertaking and so many details to address. So let's be optimistic and go forward and conclude that this reform initiative is going to be successful. How is that success going to translate to the audience members, to the members of the commercial spaceflight industry?
Well, let's start from the DoD perspective. I'm from the DoD, Tony's from the Department of State. The DoD, we love our space industrial base. It is very valuable to us. It is valuable to our DoD, to our national security, and it is a key tenet in a lot of the new policies that have come out, that it's actually written in there that we need to protect our space industrial base, and we need to help it. And that is the major goal of the export control reform. We have heard your cries for years of the burdens of export control, the confusion, the non-transparency, the administrative burdens that it puts on transfer, especially on those second and third tier companies, those smaller companies that can't afford an entire export control office to look into this and research and make sure they don't violate any of our license agreements or anything like that. So that's the effect that we're hoping to have. We are looking to narrow down and identify exactly the technologies that we want to protect that do require this extra look and these extra protections, and everything else we want to give back to the space industry and make it easy for you to sell to our friends, to our allies, to anyone in the world that wants to buy it, except for sanctioned countries. We can't sell to sanctioned countries. But we want to make it easy and help you grow your industry. So, and then Plan B, it's really been an incremental process, so we're not going to come back and say, well, it's not going to work, because we are moving forward. We've rewritten the USML list. We've got them out for comment. We're moving forward with doing that. So maybe the single agency is kind of far off, and that's maybe at higher risk of not being achieved. But if we can just continue on with the phase that we're at, this USML rewrite, that will still help the space industrial base really well.
So,
if I can jump in there,
please.
If I can jump in there, Franceska, what does it mean to the commercial space industry? As Mr. Gates said, we want to build higher fences around fewer things. The unfortunate, I'll say the unfortunate reality for those of you in the audience is that the critical technologies that you need to achieve the goal for commercial spaceflight are also the same critical technologies that an adversary would need to place a bomb on target downrange. And so the chances that your critical technologies are going to fall outside of that zone that has lesser controls, I wouldn't hold out much hope for that based on all the expert analysis that's been done so far. For those on the commercial communications side of space, I didn't mention that, particularly in Category 15, any relief in Category 15, which is spacecraft and associated articles, any relief in that category must come via legislative relief through Congress, because in 1999, Congress passed the Strom-Thurmond National Defense Authorization Act, which mandated that the U.S. government control all spacecraft and associated items under the USML as Category 15. A future question, I believe, will reveal how we're attacking that problem.
That's right.
Thank you.
Well, thank you. So, Luann, before we leave your questions, I want to make sure the audience understands all the hard work you've done on the HR 1248 report. And a lot of people don't know exactly what it is, and people like me just throw out these like letters and numbers. HR 1248, I think everybody knows what that means. Can you please talk a little bit about the report? I know you personally worked so hard on it.
Well, a lot of people did. There was every group within the DoD, and then it branched out into the interagency, that it was really a lot of work by a lot of people. And the 1248, what Congress asked us to look at, they asked DoD and state to do an assessment of Category 15 of spacecraft items that are currently controlled on the USML, and determine what the risks were if we were to move them off of the USML and move them on to the Commerce Control List. And like Tony had pointed out, it's been legislated that since the mid-90s that everything spacecraft related be on the USML. So that's everything, nuts, bolts, screws, leather washers, wires, everything is on the USML. So this is the risk assessment we had to do, and we had to look at every type of satellite, every subsystem on the satellite, and the components underneath those subsystems, so that we could give Congress a thorough, honest estimate of which of these systems have national security implications and which don't. And you can guess that a lot of them don't. In fact, the satellite bus in general, without any payloads, without any special performance parameters, but just most of the satellite buses, any of those parts aren't necessarily critical or unique to a military capability. Communication satellites, as long as they're not encrypted and don't have encryption on them, or military encryption on them, are not particularly unique or a critical military function. And some of the remote sensing satellites also, which that was a big revelation even on the DoD side, because we didn't think we would get that far. But we actually did. And the remote sensing is, within remote sensing, we couldn't say all remote sensing, of course, so we had to draw a line. We had to find a technical line of where became the military capability and what was not. And what we wanted to do was get with Paula and NASA and help that world to get a lot of the scientific and those kind of instrumented, Earth-observing scientific satellites off of the USML, because they're not necessarily military related. They have a lot of science on them, but it's not military critical technology. So that's the remote sensing area that we tried to identify. And then the report, once we had our lines, we call them bright lines of what was critical and what wasn't, then we went to the interagency and we went to Commerce and we struck some deals with how Commerce could control these items if we moved them over. And specifically, this had to do with the sanctioned countries. Even though these items we said don't have a unique military function, we still don't want them going to sanctioned countries, such as China, Iran, North Korea. And so Commerce agreed to do that for us. They agreed to change their regulations such that they had ITAR-like ban on the Commerce list. And then what we needed also is the final recommendation was to Congress to please pass a law to allow us to move items off of the USML and to continue doing these type of reviews every few years so that we can keep up with technology. So that's basically what the 1248 report did. And how it plays into the bigger ECR initiative is because, like Tony had said, Category 15 is stuck. It's stuck in time. Everything spacecraft related is going to be on the USML until Congress does something. And they needed this report to assure them that what happened with China and Hughes and satellite communications back in the 90s would not happen again. That it's okay to put this technology on the Commerce Control List and control it appropriately, and we're not going to have a repeat of that. And that was the report they needed, and hopefully they'll get the legislation that we need, and then we can move forward.
Great, thank you, Luann.
Sure.
So I know a lot of you are either new to export control or you've heard about the horror that is export control and the alphabet soup that makes it even more difficult. So just let me recap very briefly the letters you need to keep in mind. So USML, which we sometimes sort of shorthand as ML, stands for United States Munitions List, and it is comprised of many, many categories. I forget the exact number, and these people know.
21.
Thank you, 21. I knew he knew the exact number. I was going to say 20. Good thing I didn't. And the categories that this crowd really needs to worry about is Category 4, which are the basically launch vehicles, and Category 15, which are spacecraft and spacecraft components. So 4 very important letters. United States Munitions List forms part of the ITAR. If your stuff is on the USML, you are controlled by the ITAR. You must call Tony, you must call Bob and get a license to export, to share with foreign nationals your stuff that is enumerated on either Category 4 or Category 15 of the United States Munitions List. And then there's another export control regime called the Export Administration Regulations, and the list on the EAR, exactly right, is called the Commerce Control List, or CCL. There'll be a quiz at lunch, and I think it's going to be an open book test. So, and I've got multiple copies of the ITAR with me, so I'll pass them out so you have those notes so you can get an A+ on your test.
If I could also, I'd like to dispel a common myth of export control reform. The items that we're proposing to take off of the United States Munitions List are not, underline not, foot stomp not, being decontrolled. The control is being moved from the Department of State over to the Department of Commerce. So they would go from the United States Munitions List control to the CCL control. In some cases, Commerce has broader authorities to grant exemptions. And so even though it goes to the CCL, you may never need a license for it because it may fall into one of those categories. So they have broader authorities. For those items which are unique to military and there is no dual use purpose for the item, but for which the Department of State and the big interagency has decided we don't need the higher fences, they're going to go to the Commerce Control List in a 600 series export control classification number. So they will have USML-like controls on the Commerce side, but then again, Commerce's broad authorities will be able to put in place for granting exemptions and broad country policy type things. So please don't anybody take away from this that export control reform involves the decontrol of anything. That's the hardest soundbite we have had to get through to the politicians and the members who have to take action with regards to moving some of these items. Is we are not decontrolling, we're just switching the control, the jurisdiction and the control.
That's very important. Thank you, Tony. So, Paula, I am going to throw a bunch of questions at you that are all sort of in the same neighborhood, and it's really based on questions that I get from people in the industry when clients come to me and they're new to export control issues. Clients work on NASA projects. They work with NASA. They've worked with NASA for years. Now they want to start something entrepreneurial. They want to take advantage of the new commercial space direction that NASA has embraced and is encouraging. So they say to me, I don't really need your services because I'm working a NASA program, so export control doesn't apply. And clearly, if I'm working a NASA program, it doesn't apply because NASA has so many international partners. I mean, just come on, Franceska, just look at the space station. How could export control, how could the ITAR apply to such a scenario? And then I tell them the truth and they walk out and they're angry at me, they think I'm crazy. So I want them to hear it from you. Can you please tell us, I don't want to be yelled at least not today. can you please tell everybody, how does NASA manage export control? Does it apply to NASA? And I know it does because that's what you do all day.
Absolutely. NASA has an export control program. We get licenses for hardware. We do not get TAAs, but we submit licenses to state and commerce all the time when we need to export hardware. We do enjoy some exemptions and exceptions. Exemptions are on the ITAR, exceptions are under the EAR, which cover NASA civil servant work when we have an international agreement in place. We look at our international agreement as NASA's TAA, if you will. It has the same tech transfer clauses that complement states' DSP 83 non-transfer end-use requirements. And our international partners are bound to, if we have to give them export-controlled technical data, they are bound to protect it and only use it for the purpose of that cooperative effort. There's maybe one exemption under the ITAR. We can, 125.4b3, we can have our contractor, if we have a direct contract with you and you're implementing a NASA program, and we want you to provide specific technical data that's not missile tech and not design data, you can do that. Our contracting officer will write a letter to the company saying transfer this specific data to this international partner for this purpose. But we cannot give our U.S. contractors authority to perform a defense service. You have to get a TAA for that. So you're right. It's a government program. NASA has to comply. NASA gets licenses, and we also do voluntary disclosures when we mess up, which does happen.
That's very helpful. Thank you, Paula. And let me step back into the alphabet soup for a minute. So TAA, for those of you who don't know, a TAA is a form of an ITAR license, but it actually takes the form of an agreement, and that's what the last A stands for. T, technical, A, assistance, A, agreement, technical assistance agreement. And again, it's a form of an ITAR license. The DSP 83 that Paula mentioned, that is literally an ITAR form, a form DSP 83, and the parties to an export have to sign this to ensure that they understand that this thing that's been exported cannot be transferred. It must stay put with the very limited use and end user for whom that export has been authorized. So I'm going to try to catch all the acronyms as we go through them, but if I don't hit any, just let us know when we go through the Q&A. So great. So thank you, Paula. Tony, I want to come back to you before we hit Bob with some questions, because I think it's a good time to talk about what you said before about how with respect to spacecraft, there's specific legislation, a specific act of Congress that caused satellites to be on Category 15 of the United States munitions list. And to get satellites off of Category 15, off of the US munitions list, and back onto the Commerce Control list of the Department of Commerce, there must be legislative action. There must be an act of Congress. In other words, it took an act of Congress to put them on the USML. There must be an act of Congress to take them off the US munitions list. And I understand that there's legislation to that effect, and there's all sorts of talk inside the Beltway and rumors primarily about what its fate is and what it will actually accomplish if it passes. Can you talk about the legislation?
Everything that I'm going to describe about the legislation is publicly available from multiple bloggers. As a matter of fact, the space news that ICPS so graciously put in our welcome packages actually has an article in it regarding comments by administration and congressional officials last week at the ComStack meeting, Commercial Space Transportation Advisory Review Council. I'll guess that that's what it stands for. Currently, there is legislation to return, pending legislation to grant the authority for the president to make the determination on the proper controls for spacecraft and associated articles. It's currently nestled in the National Defense Authorization Act, which was passed by the House. The Senate has not yet taken up the NDA